I'm Lauren Lewis from Trudie Broekmann Attorneys.
And I'm Trudie Broekmann. We're a law firm specializing in consumer law based in Cape Town, South Africa. We have recently been inundated with 360 clients complaining to us about their timeshare and requesting us to cancel the contracts and claim their money back. The timeshare service providers range from Quality Vacation Club, Flexi Club, the Holiday Club, African Club Innovations, Zimbali, Dream Vacations Club, Multi-Destinations Club, Sondela, Mabilingwe, Premier Private Resorts, and several more.
Our 360 timeshare clients have all come to us with very similar complaints, ranging from the fact that they were ambushed at the marketing presentation they attended when they signed up for their timeshare contracts. The contracts themselves were marketed as an investment, but on further investigation, it was discovered that it's not an investment at all. For example, our clients paid a purchase price of about 30,000 Rand for 30 points in some of the timeshare companies, only to discover that the resale value of those points are about a tenth of what they actually paid for the timeshare points. The other complaint from our clients is that they've been unable to obtain a reservation despite trying to book a reservation countless times with the timeshare company. When they tried to cancel their contracts, they were told by the timeshare company that they cannot cancel the contract because it's a contract in perpetuity. That means that it's a lifetime contract and only expires upon the death of the timeshare member. Furthermore, they were told they can't cancel because it's a purchase agreement and that the only way they can get out of these contracts is to sell their points. And as I've said, the resale value of these points is substantially less than what the clients paid for the points. Some other examples are that the quality of the accommodation has not met the standard that was marketed to the clients, or that it didn't represent the value when you consider the annual management fees that our clients are expected to pay under these timeshare contracts. For example, we have one client who for the past 6 years has only been able to obtain camping accommodation with his Quality Vacation Club points, and he's expected to pay an annual levy of about 11,000 Rand, but the camping accommodation that he's able to reserve, which is for 7 nights camping at Sondela, equates to a value of about 6,000 Rand. So he's paying double in management fees of the value of the accommodation that he's actually able to reserve with his timeshare points.
The Consumer Protection Act, which came into effect in 2011, applies to timeshare contracts. The body that's supposed to enforce this act is the National Consumer Commission, and they have also been inundated with timeshare complaints. As a result, they commissioned a report which was released at the end of 2018. This is it, and it's a report which is severely critical of a range of industry practices. It also makes a wide variety, maybe 36 or more of them, of recommendations that need to be implemented primarily by the National Consumer Commission. We are not holding our breath that those recommendations will be implemented very quickly, as we have seen very little of that to date.
During the course of researching the law that applies to timeshare contracts, we have discovered that the timeshare contracts themselves generally fail to comply with the Consumer Protection Act. If it is a credit agreement, then it fails to comply with the National Credit Act, and it fails to comply with the Property Timesharing Control Act, which is a specific piece of legislation designed to regulate the timesharing industry. As a result of this non-compliance, we maintain that the timeshare contracts are generally invalid or void. Now, when we talk about an invalid agreement or a void agreement in the law, it means as if under the law, the agreement never existed between the parties. So the consequence of an invalid or void agreement is that both parties who are party to the agreement must be placed in the position they were in prior to the agreement being concluded. So with our timeshare companies, because these agreements are invalid, we maintain that our clients are entitled to a refund of all the money they have ever paid the timeshare company. This includes your management fees or your annual levy, whatever the timeshare company chooses to call it, and the purchase price that you paid for the points. Practically speaking, how we are trying to achieve this refund for our clients is that we draft a very detailed cancellation letter setting out all the grounds of voidness or invalidity due to statutory non-compliance. We also record all the breaches of the agreement where our clients have not been able to reserve accommodation or where the accommodation has not been up to the standard that was marketed to them. We list all these breaches in the cancellation letter, and we send this cancellation letter on to the timeshare company. The response that we've received to our cancellation letter has varied across the different timeshare companies. We've had particular success with Easy Holiday Clubs, where all of our clients have been refunded the purchase price as well as the management fees that they've paid to Easy Holiday Clubs, less obviously the value of the accommodation that they've been able to book through the use of the Easy Holiday Club points. Timeshare companies, however, like the Holiday Club and QVC, have been very resistant to acknowledge the voidness or invalidity of the agreement and have not been willing to accept the cancellation of their contracts. As a result, we will be embarking on a legal action to reclaim the money back for our clients.
Now we are finding that in response to our cancellation letters, the timeshare companies generally are not paying back our clients' money as they should. As a result, we are starting with a test case in the Pretoria High Court in which we are claiming back the money for one of our clients. Please be patient with us and with the legal process that will probably take 2 to 3 years to complete. We've involved a senior advocate who is experienced in dealing with class actions because we have such a large group of clients that we are representing. We will be reporting back to our client base on a regular basis on the progress with the test case. And once we are completed and we have a judgment which says that QVC must pay back the money, then we will approach QVC again on behalf of the rest of our group of clients, and similarly with the other timeshare companies to claim back the group's money paid to the timeshare company over the years. The benefit of this approach is that there are economies of scale for legal costs. So whereas if you had done this on your own, there would be a vast amount payable in terms of legal fees. If we have a group of 100 timeshare clients who are claiming from Quality Vacation Club, for example, you are paying 1% of what the legal fees would normally have been. If we have 1,000 clients, it goes down to 0.1%. So this method ensures especially good quality for money for your legal fees.
Another response we've received to our cancellation letters by the timeshare companies is to request payment from our clients of a hefty cancellation penalty. With our Quality Vacation Club clients, we've noticed that the cancellation penalty is generally equivalent of 2 years' worth of management fees. So this is in the region of about 24,000 Rand that Quality Vacation Club are asking our clients to pay in order to cancel the agreement. Because we maintain that the agreement is invalid or void, we have advised our clients not to pay any money to Quality Vacation Club and definitely not to pay the cancellation penalty. We maintain that under the invalid agreement, no money was ever due to Quality Vacation Club or any of the other timeshare companies, and as such, our clients are in fact entitled to a full refund of all monies they have paid to the timeshare companies, less obviously the use that they've received from the timeshare company.
You may wonder how the procedure works if you wish to instruct our firm to cancel your contract and claim your money back. Well, once you have contacted us by email or on our website or telephonically, we'll send you a detailed email setting out how the process works and what we need from you. In the email, we'll ask you for payment of a deposit, which is an initial standard amount, which is intended to cover at least the letter of cancellation for you. you will note that that amount will be less than your annual levy amount payable to the timeshare company. Once you've made the payment to us, we recommend that you don't make any further payments to the timeshare company. No use throwing good money after bad. You may be worried that there might be debt collection procedures against you or further trouble from the timeshare company's side. We want to reassure you that there's no need to lose any sleep on that front. If you are contacted by a debt collector, all you do is say, don't speak to me, speak to my attorney. Here are Trudie Broekmann's contact details. Okay. And we will deal with the debt collectors for you. In fact, we expect that they won't, in fact, contact us. In our experience, you will certainly not be sued by the timeshare company. They cannot afford the huge risk of having an adverse judgment against them, which says that their contracts, all of their contracts with all of their customers are void, invalid from the start. We have had 2 of our clients, so there's a remote risk of that, getting blacklisted. It's the easiest thing in the world for us to reverse that blacklisting. We simply send the credit bureau a copy of the letter of cancellation, and they immediately reverse that. So absolutely no need to lose any sleep. You can stop paying the timeshare company the moment that you've paid us our deposit. We've also had some trouble with timeshare companies just ignoring our letters of demand and continuing to deduct money from our clients' accounts by way of debit order. Now, you can reverse the debit order electronically if you have internet banking on most of the bank's websites, and we can also assist you by writing a little note to your bank manager, who will also do those reversals for you. So once again, an easy procedure, but it's insulting to our clients that this continues to happen, and as a result, we have submitted a dozen or so, and we're expecting to do a few more complaints to the National Consumer Commission against the timeshare companies who are harassing our clients in this manner. We're going to be progressing those complaints to the National Consumer Tribunal, and there we will ask for the maximum penalty that can be imposed under the Consumer Protection Act for contravention of the Act against initially Quality Vacation Club. That's a fine of R1 million or 10% of their turnover for the last financial year. If anything that Lauren and I have been saying has hit a chord with you, please feel free to contact us on the contact details provided on the screen.